Farstad Supply against Enviroco Limited and another.
Yes, Mr. Clark.
Lords, I appear along with my learned friend Mr O'Brien for the appellants in this case. My learned friends Mr Howie and Ms Derabegovic-Broom appear for the respondents. Lords, regrettably in the bundle which came down, tabs 16 and 29 had been omitted. These have now been supplied and the Lordship should have them on the benches. Lords, the motion for the appellants is to invite your Lordships to allow the appeal and to recall the interlocutor dated the 1st of May 2009 of the extra division. And your Lordships will have seen from the written cases that the way in which parties have approached the issues is to divide them into two broad chapters. First of all, the matter of statutory interpretation of the terms of Section 3, subsection 2 of the 1940 Act, and secondly, the matter of the meaning and effect of clause 33.5 in the Charter Party. And I'm proposing just to follow that very broad structure. Those are the two chapters. But perhaps I should just say at the outset...
Sorry to interrupt you, just to be quite sure what your motion is. Do we restore the Lord Ordinary's interlocutor? Or is there something about it that doesn't need to be restored?
I'm sorry, my Lord. No, I should have said that. There's no difficulty, as I understand it, with simply restoring the Lord Ordinary's interlocutor.
Right. I
don't think there's a problem with that. I don't have anything extra to add to that. It would be recalling the Inner House and restoring the Lord Hodges' interlocutor.
Can you just inform me, excuse me for not knowing, the statutory point, the first point, is a matter of Scottish law. The interpretation point is a matter of English law, because the Charter Party is subject to English law.
Yes.
Is English law something of which, in the Scots, in this court, I think we take notice of both, or know both, but in Scots courts, is English law a matter of foreign law which has to be proved, or is it a matter of which you take notice?
I think the answer to that is if either of the parties took the point that there was some speciality of English law which would change the approach one should take to it, then it would be pled and one would deal with it that way. But neither party has done that.
I mean, I just noticed that there were comments in the judgments or in the argument about English law being different on this point and so on. But anyway, in this court it doesn't arise.
It doesn't arise, Lord, no. My Lords, my submission really on both chapters is that it is simple and can be summarised, I think, quite succinctly. It is that the words of the statute and the language in the contract should be given its ordinary and natural meaning, the consequence of which I would respectfully submit is that the respondents have no valid claim against the third party for contribution, and if your Lordships are with me on that, then the appeal should be allowed. But clearly there's much more to it than that by way of submission, and if I could perhaps just outline broadly the structure I was planning to follow, it is first of all to look at the first chapter, the statutory provision, in three sub-parts, fairly briefly. First of all, to look at the underlying rationale of the right to seek contribution. Secondly, to look at the language of the provision. And thirdly, to consider whether the pursuer and the third party can, by their contract, affect the defender's claim for contribution. And on the last point, there's a decision of the House of Lords applying English law. It's tab 6 of the bundle, and I'll come to that in due course. So those are the three brief subparts on the first chapter. Chapter 2 on the Charter Party will be in two subparts. First of all, three short points on the approach to construction, and then secondly, I plan to just look at the meaning and effect of the provision in question. Lords, if I could begin then with
You're really here both for yourself and for the third parties, is that right?
That's effectively right, my Lord, yes. The way it was done before the commercial court was simply that the third party took no part in the debate because the pursuers were taking those points. Whether formally the pursuers are representing the third parties hasn't really been the subject of detailed discussion, but the third party simply said, if you're taking the debate points, we drop out and you do it.
But your plan concedes that it can't recover from the Charter, does it? Yeah.
Yes, that's right, my lord. Yes, yes, absolutely. Yes.
Really, the Charter's interest in not having the.
Sorry, my lord.
It's really the Charter's interest in not having the. In not having. I mean, it's really saying that the environments against the Charter are irrelevant.
Indeed,
Isn't it?
indeed, that's right.
It's a right of relief against the
Yes,
Charter.
exactly.
Isn't it?
It is saying that the averments by the defender directed at the Charterer seeking contribution under Section 3.2 are irrelevant. I think it's fair to say the pleadings don't actually map out in detail that it's Section 3.2 which the defender is relying on, but certainly the parties have worked on the basis that that is the defender's case. But that's right.
Is it common ground that that there's no distinction between subsections 1 and 2? That if in this case the owners had sued both the contractor and the charterer, then the question would be whether or not the charterer was liable to the owners on the true construction of Section 3, subsection 1.
Yeah.
And that is really the same question
That's right.
as in subsection 2. So one can just focus on subsection 1, assume all the parties were here, and decide whether there's a liability or not. Is that right?
I think it's effectively the same question, although there are some specialities in the language of subsection 2.
But is anybody suggesting you get a different result?
I don't think so, my lord, no.
One could focus on the simple subsection 1, and then you get the answer to subsection 2.
Yeah, so I think that's
Except
effectively
it was
right.
time barred against the. It was time barred.
Yeah, there may be
Subject to time bar, yeah.
yeah, there may be questions of time bar.
Subject to time bar, yeah.
Subject to that, but it's the same basic point. Is the charterer a person who, if I sue them as the pursuer in the action, someone who I can hold liable to me, and whether it's joint and several under Section 3.1 or under Section 3.2 is really not much.
And is it common ground on the true construction of the charter party that if the clause is an exclusion clause and not an indemnity clause, then the appeal's bound to succeed?
I don't think it is, my lord, because it was before the Inner House. It was accepted. There was a concession, if that's the right way to put it, by my learned friend that an exclusion clause between A and C, pursuer and third party, could and indeed would remove the right of contribution.
I think it might be wise for you not to assume that it is common ground at that particular point.
Yeah.
But as far as your own position is concerned, you appear for the pursuers.
Yes.
And would I be right in thinking that the effect of the indemnity is that you would be you would be liable to reimburse the charterer for the cost of resisting an action against them, as well as simply paying the damages, if any, that were awarded. So you're really here in implement of the obligation to hold harmless and indemnify and everything else.
One can certainly look at it that way, my lord. Yes, that I'm here in implement. It wasn't really the subject of detailed discussion as to whether one was actually, carrying it through to that extent or representing the third party. But it's fair to construe it as one simply acting in implement of clause 33.5 in the charter party,
Yes.
and thereby, as it were, funding and dealing with the third party's position. I think that's.
We've got a vital interest
Yes, indeed.
to intervene effectively in
Yes.
English terminology and,
Yes.
And to argue that there is no right of contribution, because
absolutely.
otherwise you have to cough up by way of indemnity.
And it's quite sensible for you to actually pay the cost of all of this yourselves. At least you can control the budget to some extent.
Indeed.
And not have to argue about overindulgence on the part of ASCO.
Yes.
All this assumes, of course, that Enviroco are at risk, and that's something that's going to be debated in the Scottish proceedings, but rather remarkably, there are also separate English proceedings, we know.
Yes.
Anyway, we needn't go into that. It seems rather odd that you can have two sets of proceedings about the same liability.
Yes, I'm not completely au fait with the English proceedings, my lord.
Well, they're claiming on some basis or other a declaration that they are within the scope of the exemption clause as an affiliate. Quite what they intend to do with the declaration is not entirely clear from the papers I've seen, but it doesn't matter perhaps. But the basic point is it's very odd to be claiming a declaration in proceedings separate from the Scots proceedings.
Yeah.
Anyway, you can't throw light on that.
It's simply how matters have panned out, my lord. So, turning to the question of the underlying rationale of the right to seek contribution, there has been some discussion of this in English and in Scots law in the House of Lords, and I plan to look first of all at tab 6 I'm sorry, my Lords, tab 18, the case of the Royal Brompton Hospital against Hammond and others.
We're going back to common law now, are we, the origins of...
Yes, my Lord, yes, indeed so.
Just a postscript to the last discussion. I see there's an exclusive English jurisdiction clause in the Charter Party.
Yes.
So maybe that's the explanation.
Well, then one might ask why they're being sued in Scotland. I suppose no. They could raise the defence in Scotland, though. That wouldn't exclude the jurisdiction clause, would it? Anyway, it doesn't. You may be right. That may be the answer.
Yeah. Rods, in the Royal Brompton case, it was a case about a building contract. The employer sued the architect, and the architect sought contribution from the contractor. And it's probably enough not to get too heavily involved in the facts and simply to look at what was held, because it primarily concerned the question of the meaning of the expression "the same damage" in the English statute, the Civil Liability Contribution Act 1978. And one sees just at the bottom of the first page, page 225, using the pagination in the bundle, that it was held dismissing the appeal that although the purpose of the 1978 Act was to enlarge the previously restricted category of causes of action capable of giving rise to a claim for contribution, the requirement that contributors were subject to a common shared liability remained at the root of the contribution principle. The right to contribution conferred by sections 1.1 and 6.1 might be claimed from any other person, whatever the legal basis of that person's liability, provided that it was in respect of the same damage, and that was the issue in the case. That those words bore their natural and ordinary meaning and were to be applied without gloss. And then it goes on to say that the damage sought from the defendant architect was different, or the damage in respect of the claim against the architect was different from that in respect of his claim for contribution. So that was really what it was about. But there's some discussion of the underlying rationale. First of all, in the speech of Lord Bingham of Cornhill, just at page 227 of the bundle, in paragraph F, he refers to the fact that that appeal turns on the interpretation of 6 words. And in my submission, the appeal in this case in relation to the interpretation point turns on a few words as well. And then in paragraph 2, he says that the law has for many centuries recognised the existence of situations in which, if B is called upon to discharge a legal obligation owed to A, fairness demands that B should be entitled to claim a contribution from other parties subject with him to that obligation, stressing the need for the shared obligation. And
H, I think the obvious justice of requiring a common liability should be shared.
Yeah, exactly so, Lord Judge. And the theme is developed on page 229 in paragraphs 5 and 6, where he says in paragraph 5, it begins by saying it's plain beyond argument that one important object of the 1978 Act was to widen the classes of persons between whom claims for contribution would lie, and to enlarge the hitherto restricted category of causes of action capable of giving rise to such a claim. But he then says this: it is, however, as I understand, a constant theme of the law of contribution from the beginning, that B's claim to share with others his liability to A rests upon the fact that they, whether equally with B or not, are subject to a common liability to A. And then in paragraph 6, just developing the point slightly further, he says, when any claim for contribution falls to be decided, the following questions, in my opinion, arise. 1, what damage has A suffered? 2, is B liable to A in respect of that damage? And 3, is C also liable to A in respect of that damage or some of it? And he then deals with the position at the striking out stage in the next sentence, and then just below letter H, towards the end of the line. I do not think it matters greatly whether in phrasing those questions one speaks, as the 1978 Act does, of damage or loss or harm, provided it is borne in mind, and it's first of all that damage doesn't mean damages. And he goes on to say at the end of that line, and that B's right to contribution by C depends on the damage, loss or harm for which B is liable to A, corresponding, even if in part only, with the damage, loss or harm for which C is liable to A. This seems to me to accord with the underlying equity of the situation. It's obviously fair that C contributes to B a fair share of what both B and C owe in law to A, but obviously unfair that C should contribute to B any share of what B may owe in law to A, but C doesn't. And in my submission, the language of obligation, liability, and indeed that expression of owing in law is important in understanding the underlying rationale of the right to contribution, and that is what one is looking for here. Effectively, does the third party owe in law to the pursuer?
And sorry, beg your pardon. Your position would be that looks not just to the merits, but also to any reason why that obligation may not be owed, possibly because of a statutory provision, or a contractual provision, yes, or the fact that the right has been extinguished, or the obligation has been extinguished by limitation at the date when the action is raised, or yes, whatever else.
Yes, just any complete defence open to the pursuer in the action, and in the particular context of this case, it's the defence based upon the contractual term. And one simply says that as a result of the charter party, ASCO, the third party, doesn't have an obligation. Indeed, there's a question raised in our case about whether, in fact, there's any duty of care in the first place on the part of ASCO as standing the terms of the contract. But that's really the heart of the case in my submission, my Lord, just whether standing the terms of the contract, and looking at this kind of language that Lord Bingham uses, it can be said that the third party owed in law an obligation of the same kind as the defender. And
that paragraph is the answer, isn't it, to Lady Peyton's view that the result that the Inner House by a majority reached was broadly equitable, because her view was based on the fact that there happens to be an indemnity here between the owners, your clients, and the charterers, but in many cases there wouldn't be. There'd simply be an exemption clause, and there'd be no indemnity, and the result would be that someone would be held liable by the back door when they couldn't be held liable by the front door.
Exactly so, yeah. But that is it, my Lord. I think Lady Peyton, with respect, seemed to elide the underlying basis for the right of contribution in the first place.
That's why the concession is correct.
Yeah. But it does seem from the written case, and as my Lord Hope mentioned, it's better not to assume that it's being made, because the written case for the respondent seems to suggest that the concession is no longer there.
Well, Lord Carloway made the point, didn't he, for them, effectively. I mean, he didn't think that the concession was rightly made.
Yeah, he didn't. So he didn't accept the concession at all. That's right. In the speech of Lord Hope in Royal Brompton, there's useful discussion about how the Scottish underlying rationale, if you like, is really the same. And that's...
Just back, Lord, just before we leave, Lord Bingham, the old common law position was that liability had to be joint. Is that right? But now it's joint or separate, as long as it's the same damage.
Yes. I think that's my understanding of it, my Lord. Yes.
That's the position, the old position in English law, was it? It was.
I think so.
In effect, it's a pro rata division.
Well, I think you couldn't have contribution.
No contribution between wrongdoers. Joint tortfeasors, no contribution.
That was the Merriweather. We'll come to that just next. That's the Merriweather case, but I understand. So it's 1935 when one first gets the statutory position in England, and that is actually quite close to the Scottish legislation, and that's when one gets the introduction of the joint point. But that's in fact made clear in Lord Hope's speech in this same case. Again, just using the pagination in the bundle, it's at page 242. And it's just at letter E, just below letter E on page 1414 of the report, page 242 of the bundle.
Yes.
And this is the point we've just been discussing, my Lords. As my noble and learned friend Lord Bingham of Cornhill has explained, the common law did not favour the remedy of relief between joint tortfeasors. Merriweather, the principle upon which the decision in that case was based appears to have been that a wrongdoer could not seek redress from another where he is presumed to have known that what he was doing was wrong. Adamson and then Weld Lundell. Then Your Lordship was on to say, it is plain from the comments on it in Palmer against Wick and Pulteney Town Steam Shipping Company Limited by Lord Herschel, Lord Watson and Lord Halsbury, the rule was not one which they regarded with much favour. That was a case where damages had been claimed by the widow of a man who was killed by the fall of part of the tackle when the cargo of a vessel was being discharged at Grangemouth. Both the shipowner and the stevedore had been found liable to the widow in damages and expenses. It was held that the shipowner was entitled to recover half of the damages and expenses from the stevedore. That was the pro rata Scottish common law right of relief, as the rule that there was no contribution between wrongdoers didn't apply in Scotland. But as Lord Herschel said, it was too late for the decision in Merriweather to be questioned. It wasn't until the rule was removed by Section 6 of the 1935 Act that it became possible in this jurisdiction for the liability and damages to be distributed between joint or concurrent tortfeasors. So it's the statute nod which brings in the distribution between joint or concurrent tortfeasors. Section 6.2 of that Act went one step further, as it enabled the liability to be apportioned equitably between them and not just equally. This reform, and in other words, the equitable apportionment, this reform was extended to Scotland by Section 3 of the 1940 Act, the section we're looking at. So the Scottish common law position was pro rata right of relief. One sees that in Palmer. I'll come to Palmer shortly. And the principal change wrought by Section 3 was to allow equitable apportionment rather than simply the pro rata right of relief that was there.
Was it intended to make any other change?
In my submission, when one looks at the language of the Act, it certainly doesn't affect what I've been calling the underlying rationale, the need for the common obligation, the common liability. And I don't think any other material change is wrought by the provision. There's some discussion of that in one of the cases, which I'll come back to, my Lord. But that's certainly the principal change, and Lord Hope notices that in this case. And then just turning to page 245 of the bundle, just between letters C and D, still in the speech of Lord Hope, just above D, there's reference again to the Palmer case. Prior to Palmer, it was not settled whether the statement that there should be no contribution between wrongdoers was part of the law of Scotland, see National Coal Board, etc. But Lord Watson said in the Palmer case that it had been recognised in Scots law the right of relief inter se was competent to all persons concerned in and responsible for the civil consequences of the same delict. This was said to be because payment and reparation by one wrongdoer liberates the rest, and he ought in equity to have relief against the others proportionately, since by his money the others are freed from their obligation. And reference is made to Bankton, and we'll come back to see that Lord Watson mentions Bankton, and indeed that theme is endorsed in a number of cases. And Lord Hope goes on to say the words liable in respect of the same damage, which first appeared in section 6.1, etc., confirm that the concept of a common liability remains the basis of the entitlement to contribution in English law. And in my submission,
Scots law, could it be either several or joint?
does not have in mind in a common law context?
Yes, common law in Scotland.
My understanding of it is that what it's really about is tortfeasors, to use an English term, about joint wrongdoers, if you like, in a Scottish context, being liable. I think it would. My understanding is that it would have to be really a joint and several liability that one had in the Scots common law.
I think that's what I'm saying in paragraph 44. The essence of it was a joint and several liability.
Yeah. Joint and several, but those are different things, aren't they?
Joint and several.
Wait, you say in paragraph 44 jointly or severally?
Or both jointly and severally.
Because there must be, I mean, there are cases like the Kursk, yes, where, and indeed the present case is not a case of, I imagine, of joint liability. It's probably, they're separate wrongs, completely different wrongs, aren't they? So it's the same damage, so it's actually several liability in the present case, probably.
It's just a bit odd to talk about a joint obligation in the case of several liability.
Yes.
Yeah.
And I think the English rule was you couldn't get contribution in any of those situations.
You wouldn't, because that was what was, I had it wrong before, that's what was decided in the Kursk, the old rule that you couldn't get it in relation to joint obligation. obligations applied also to several
Yes.
obligations. Several
That's what
obligations.
But I mean, what is the position then, Mr. Clark? I mean, could if it was several, if it was two separate delicts contributing to produce the same damage, was there a right of contribution?
The way it's put, I think, in Palmer, and we'll come back to it, is that the right of relief inter se is competent. Like this is again in Lord Hope's discussion of it, just at letter above letter E on page 245. The right of relief is competent to all persons concerned in and responsible for the civil consequences of the same delict.
Same delict.
Yeah.
Indeed, the rationale, Palmer's rationale, was that it was the same delict, wasn't it?
Yes.
Why should that be the rationale, though? I mean, if the real underlying rationale is that you've liberated someone from their obligation, why should it matter that it's precisely the same obligation if you've effectively liberated him by paying the damage?
Yeah, yeah.
So, I mean,
It must. I think my Lord is absolutely right. It must extend. It must extend to that situation.
Well, letter C on the same page, I think, is picking that point up, isn't it? That I mean, they may have contributed in different ways, but it's the same harm,
the same harm,
the same damage.
Yeah.
And you've relieved. The theory is you've relieved the other party from having to pay for that damage because you paid it all to the party who was injured.
Yes, indeed. Well, that's right. It is the contribution, possibly in different ways, but to the same damage. And
is that is that a several liability or a joint and several?
Yeah. Well, I would see that as a joint and several liability. That the injured party can sue either of them for the
that's the tort position, isn't it?
Yeah.
I mean, you get joint liability where you are parties to a single contract, for example.
Yeah.
But I would have thought in the case where you've committed separate types of wrongdoing,
Take a ship collision case as an
it's
example.
a pure several liability, isn't it, for the same damage?
Same damage, yeah.
I haven't quite got clear in my mind what the basis of the actual substantive claims in the present case would be, but I rather suspect that the nature of what the charterers are supposed to have done wrong is different from the nature of what Enviroco are supposed to have done wrong. One is supervisory, while the other is direct, I imagine.
Yeah, that's undoubtedly right.
I'm not clear whether English law ever uses the phrase joint and several.
Yes.
It does.
Yes.
As in Scotland, would I be right that one would tend to think of it as a joint and several liability if it's the same harm?
Yes, indeed. Because there's a common result, a single common result, the same harm. What one would tend to think of it, one would use joint and several in that context.
But at any rate, whatever the common law position was, it's clear that under this statute,
Indeed.
and indeed Lord Hope makes that clear at paragraph 4,
Yes, indeed.
just above G.
Well,
the
that's
end
right,
result as regards contribution doesn't matter.
I don't think it matters. I don't think it matters. No. But the central point of this part of the discussion is, in my submission, the commonality between the underlying rationale in Scots law and that which Lord Bingham spoke of earlier in the case, and looking at it in terms of how Bankton puts it, it's a question of by the defender's money, others are freed from their obligation. They've been liberated from their obligation, and that, in my submission, is really what one has to.
So you've got to pay first.
Yeah. Now, we'll come to how the Scottish statute developed and how third-party rights didn't exist at the time when the statute was there. But that's the idea. I'm liberating you from your obligation, and that's where the equity comes from. It doesn't simply come from the fact that I've had to pay damages and that there's somebody else out there who I might be able to blame. It comes from the fact that I have freed. The defender has freed the third party from an obligation.
An obligation arising out of a breach of duty, not an obligation arising out of an agreement to indemnify.
Yeah, it's an obligation arising from a breach of a legal duty. And in this case, it is the defender's position, as I understand it, that using Bankton's term, he has liberated the third party from an obligation to make reparation effectively to these pursuers. And the question is, when one looks at the charter party, is there...
We will have when he's paid.
We will have when he's paid, yeah. Yeah.
He didn't pay, wouldn't have.
It didn't pay, wouldn't have, that's right. And there wouldn't be any basis for the, for the equity. But it's...
And all this is really a red herring if we just focus on section 3, subsection 1.
I'm simply saying, my lords, that the underlying rationale is there. The changes which the legislation makes are really about apportionment rather than the fundamentals. We'll come to the language very shortly. But this idea of liberating the rest, etc., and Bankton is pretty much cemented into the Scottish cases on this area. One finds a number of references to it. If I may just pick up on those.
I mean, the first, I mean, if we focus on subsection 1, it's got to be jointly and severally liable.
Mm-hmm.
Jointly and severally.
Yeah.
That's right.
So, I mean, we do have to decide whether, I mean, it does arise.
Supervisor.
But my submission on that, my lord, is that it would be correct, I would say, in Scots law to characterise the liability of wrongdoers, albeit committing wrongs in different ways, but for the same damage, for the same common result, as a joint and several liability.
That
Yeah,
was
what
the
you
problem in
say.
the Brompton case, wasn't it? Because it wasn't possible to say that they had actually contributed
indeed.
to the same damage, and
Indeed.
therefore the right of contribution didn't apply.
That's right.
But if you can be severally but not jointly, then severally is not enough, is that right?
Yeah.
Under the statute.
Yeah, that's right. That's right. Yeah.
In which case you'd be even better off, but you're not arguing the point.
Well, that's it. Yeah.
It's quite an important point, really. If you take a ship collision case,
Yeah, it's an important point.
where the liabilities are several, but probably for the same damage. Several because they're separate, entirely separate obligations breaches owed by each ship. I wonder if they really meant that.
Yeah.
The other point I was going to ask you, and it may be a bit of a deviation, and don't worry about it if it is, but do you know, is there authority as to whether negligent acts or omissions could include acts or omissions which were in breach of a contract to act with reasonable care in circumstances where there wouldn't necessarily be a tortious duty?
I don't know of any authority on that, my lord, no. But the only case I was going to deal with on that is Henderson and the discussion of concurrent liabilities.
Yeah, well, that's,
it doesn't really deal with
no,
that's a
that
separate
doesn't
point.
touch. I mean, that's
doesn't
where
it?
there is a concurrent
No.
tortious duty,
Yeah.
and I know there is authority under the contributory negligence statute on that sort of situation I was putting to you, but I just wondered whether there was some.
I don't think there's anything in relation to contribution. Nothing I've kind of.
Do we have our Neil and Patterson in the bundle? You'll see I refer to it at the bottom of page 245, where the House of Lords, in what was obviously an English appeal, reached the view that there was joint and several liability, where there was a single, or the whole of the damage was the result of action of people acting together.
Acting together, yeah.
It may cast some light on what is meant by joint and several.
We don't, I'm afraid, have that in the bundle, my lord. That's something which I think we can seek to deal with, if possible, in the course of.
It might be worth checking. I simply don't know. But it might elaborate a bit on what is meant by the phrase and whether there is a distinction. If people are not, as in that case appears to have been happening, people were acting together. In this case, that wouldn't be the situation.
Yeah. But yeah, one of the cases I had in mind, one of the Scottish cases, is the case of Grunwald, which is mentioned by your lordship in paragraph.
Hughes, is it?
Yeah, Grunwald, mentioned in paragraph 44.
So it does deal with the contract position.
Yeah, yeah. Well, that's yes, indeed. So basically, you can have, and indeed, I think beyond that, breaches of statutory duty, breaches of other duties. The nature of the wrong doesn't that doesn't take it out of the frame, if you like, as being a joint and several. So
But that's quite helpful to your position, isn't it? Because if contract can bring you within the scope of contribution, why can't it take you out of the scope of contribution?
yeah, I hadn't thought of putting it that way, my lord, but that's a helpful way to express it. But the basic approach is looking at the result, the common result, the damage, and simply saying, well, is there more than one party here who has breached a duty which has given rise to that common result? And that, in my submission, that's how Scots law approaches it. And accordingly, joint and several is the way that it is.
My recollection of Grunwald is it's not overburdened with reasoning.
I think that might be right, my lord. Yes, I think that might be right. But the principle, as I understand it, has been routinely accepted, and I've certainly argued a couple of cases where I've founded upon it and haven't run into great difficulty. That is how in my
We
submission.
don't have it, do we, Mr.
We don't have it, my lord. No. Again, can certainly seek to supply that.
Lord Hope, in paragraph 44, doesn't seem to draw a distinction for the purposes of the statute between joint or several and joint and several. No. He treats them as both being treated as subject to the statute. So maybe they do mean the same thing, even though the expression is... Although the expression is joint and several, it may be that they really mean joint or several.
Well, Lord Roger was quite careful not to agree with me, so his position is still open.
Same as Lord Mackay, I think.
What I was going to do is just look briefly at the other cases which refer to this underlying rationale, and I think I can take it pretty shortly. There's first of all Palmer, which is in tab 17. And I simply wanted to look at this again just to reiterate the Bankton reference in Lord Watson's speech. In page 220 of the bundle, on page 220, there's, towards the top of the page, I'm afraid this photocopy is not good, my lord, for which I apologise, but Lord Bankton and Lord Kames both affirm in the widest terms that a right of relief inter se is competent to all persons concerned in and responsible for civil consequences of the same delict, a rule which must apply a fortiori in the case of quasi-delicts. Lord Bankton, after referring to the rule that each delinquent is liable and may separately be sued for the whole, goes on to say, yet payment and reparation by one liberates the rest, and in equity he ought to have relief against them proportionably, since by his money they're freed from the obligation. So that's obviously what Lord Hope had in mind in the Royal Brompton case. It's that is how Bankton puts it.
So that's the same delict again.
Yeah. And the way that it's put just across the page on page 45, just towards the end of the first substantial paragraph, about 4.5 lines up, just after the semicolon, the claim of relief rests not upon any injury sustained by the claimant, but upon the fact, as Lord Bankton puts it, that by the use of his money, the rest have been freed from their obligation, a circumstance which in ordinary cases is sufficient, according to the law of Scotland, to raise a right of relief. So, subject to the point about the same delict, the underlying rationale is about liberating others, paying their debt effectively, and that point is carried through. One sees it, for example, in Glasgow Corporation against Turnbull in tab 13 of the bundle. Just that this is a case about a declarator of the pro rata relief at common law, but just looking at Lord Murray's opinion at page 148 at the top of the page.
Which page, sorry?
Page 148, my lord.
148, thank you.
Where it says the right to relief which arises in all these various classes of cases is in truth an equitable remedy which arises from and which ultimately rests upon the fact that the party claiming has in fact discharged the proper debt or liability of another. The right is doubtless conditioned by this. The debt or obligation, when so discharged, shall be a subsisting debt or obligation prestable against the third party, as also that payment or satisfaction of the debt was not intended by the person claiming relief to effect a liberation of the third party from his proper debt or liability. But that case went to the division. The interlocutor was recalled of consent, but as we see in one of the later cases, its history doesn't record what actually happened to it. But it's simply a reiteration of the essential theme of discharging the proper debt or liability of another. And the second last case in this series is in tab 15, National Coal Board against Thompson. Another common law right of relief case where there was a settlement and no decree. And again, just to notice references to the underlying basis. First of all, in the opinion of Lord Patrick at page 193 of the bundle, and in the third last paragraph, just about halfway down the paragraph, there's reference to Lord Watson pointing out that the claim to relief is not founded on the damage. It is based on the fact that by the use of the money of one co-delinquent, other co-delinquents have been freed from their obligation. In short, it's based on equitable consideration. So it's simply a repetition, if you like, of the same principle. And that is that's developed under reference to some older authority in the opinion of Lord Strawn, which begins on page 198. And in the paragraph, in the large paragraph in the middle of the page, he refers to Palmer. And indeed, I think it's right that in the Palmer case, Lord Watson had referred to Barnhume on the basis that he didn't support any right of relief involving joint wrongdoers. And what's happening in this passage is that Lord Strawn is saying actually there are other passages in Hume which support the position. If your lordships can see just about two-thirds, just over halfway down that substantial paragraph in the middle of the page, there's a number 124 of volume 15 of the Society's publications. The Lords have that. And it says
just above that, though, at page 381, there's an interesting quotation, I think, bearing on the question of whether there's joint and several or several liability,
yeah.
Isn't there? If several persons are concerned in any wrong or delinquency,
Yeah.
the law doesn't distribute the damages amongst the several delinquents, but holds all liable conjunctly and severally for the whole amount.
Yeah, yeah.
Of course, once there's a judgment, the obligation is joint and several, isn't it? So that before judgment, the position may be that the liabilities are several. And once there's been a judgment, at any rate, once there's been a judgment against both,
Yeah.
then the judgment is joint and several.
Yes, and it is that which one will then be enforcing as against either one of them for the whole amount, or if there's some apportionment, then having
the statute goes rather further than this principle, in as much as you're considering would he, if sued, have been liable. The fact that limitation has removed the liability is no answer to contribution.
Yeah, the statute goes the distance of would have been held liable. Yeah, and I'm going to come to that.
So when this section says the judgment of a court found jointly and severally liable in damages, it may be referring to the judgment, not the original cause of action.
Well, certainly, to be jointly and severally liable, one would have to be a co-delinquent in respect of something which produces the same result, and that, when one looks at the result, the damage, I think it's the same basic point as in the Royal Brompton case. Have they caused the same damage? And if they have, then it's a joint and several liability.
Yes, that may be the answer, because there isn't any reference to joint and several in paragraph 2.
No.
Because there's no judgment against both.
Yeah. It proceeds on the basis that, in fact, there's been an action against only one.
Yeah. So that fits with what Lord Hope said in paragraph 44 of the first case you referred to. It would enable one to give effect to that. It
would.
Yeah.
Indeed, so, my lord. In this passage, Lord Strawn goes on, and Lord Hope's absolutely right that there's discussion of the background just earlier in the paragraph. Perhaps I could just go back to that. If I just move up the paragraph to the italicised bold 381, these observations were read as meaning that Baron Hume was against contribution among wrongdoers. He said, but if several persons are concerned in any wrong or delinquency so as to be liable in reparation, our practice does not distribute the damages among the several delinquents or lay a certain portion on each of them, but holds that all liable conjunctly and severally for the whole amount. And there is no principle here, as in the case of cationers binding to the same debt, on which to imply any tacit agreement among them for mutual relief or decision of the loss. So there's a discussion of the...
I imagine that might have been division of the loss.
I think it must be, my lord. I regret to say that in these, our understanding is that the practice directions allow these electronic materials, but I regret to say I've certainly found a couple of typos in them, and that may well be one of them. I think it may well be either a typo or it was intended to mean division. But what Lord Strawn goes on to say is that if you look at other parts of Baron Hume's lectures, and this is then just down to the line about two-thirds way down that paragraph, beginning with the 1, 2, 4, on the very next page, wherever there occurs this passage, it's also to be kept in mind, even with respect to the assessment of the proper damages, that although each of the delinquents is thus answerable in solidum to the injured party for the whole amount, yet still this is in the first instance only, and without prejudice to his rateable relief, who pays the whole against his fellow delinquents. There's no sufficient reason against sustaining such a claim of relief. Considered with respect to each other, they're all pari casu, equally to blame, or at least blamable less or more. As soon as the damage is paid, the convenience of the injured party is out of question, and by making payment, any one delinquent has liberated all his associates from the claim for the entire sum, to which they equally as he had been exposed. This is utiliter gestum by him for them, and in their common concern, and gives him therefore a claim of indemnification at their hands. So it's simply making the point that one can find in Baron Hume's work support for the idea of where the equity, where it comes from. If you liberate your associates by making payment, then you're entitled to relief. And he goes back to, obviously, the Roman law concept of utiliter gestum, which I understand simply to be part of the law on negotiorum gestio, and I would understand it to be where one party has unjustifiably, as it were, gained wealth at the expense of another. But in any event...
It means that, it seems to me they did something which was useful to the other party, and therefore the other party has to pay for it.
And its usefulness in this context is to liberate him from an obligation that he would otherwise be subject to. And again, just looking at the history of it and the institutional writers, at the bottom of page 198, just in the last few words, Lord Strawn says, both Lord Stair and Lord Bankton have stated that this right arises from the natural obligation of recompense. Lord Stair saying that he who paid not only for himself but for others is not presumed to do it animo donandi. And then just in the next paragraph on that page, page 199, his lordship summarises matters thus. I therefore reach the conclusion that at common law the right of relief to which a co-delinquent is entitled arises not from a decree against him, but simply from the circumstances that he has paid more than his share, and has thus benefited other delinquents bound jointly and severally with him. In other words, he has a right of relief not because he's been forced to pay, but solely because he has paid the share of other co-delinquents.
So you wouldn't need a judgment?
Yes.
No.
I mean, that was the point in this case, wasn't it?
That's right, my Lord. Yes, that's what this case is about. There was a settlement and no decree. So
But
that
they held
was the
that
argument.
there was an essential, wasn't it, didn't they? Dissenting Lord Strawn. So this is Lord Strawn dissenting. Actually.
Yeah, he's dissenting on the question of whether a decree was was needed. The majority said you would need a judgment, you would need a decree, because that would constitute the debt, as I understand it. But in this passage he's going back to the underlying rationale and where the equitable right comes from, solely because he has paid the share of his other co-delinquents. And just to finish on this point, in the COMEX case in tab 6...
So in Scotland you would have needed a decree, would you? A decree between who and who?
Well, you would need to have the pursuer succeeding against one of the co-delinquents, and that would then be a decree against him, causing him to be required to pay the whole amount, and that would then, as I understand it, found his claim because he has paid and liberated the others.
Not easy to see why you need a decree, because if you're the defender who recognises the liability, you say, well, I admit that I'm liable, and here's my cheque, and I'm now going to sue the...
Well, that's what this next case discusses, because...
Well, the head note says that some equivalent instrument constituting the debt would suffice. I haven't delved into the rather dense majority judgments to see what that instrument might be, but... It's
possible to have it by means of such an instrument, but when we come to the statute and its requirements, that's what COMEX discusses, and essentially it is still necessary to have a decree, although that can be a decree not necessarily after a contested litigation, but something which arises after settlement. And what one sees that discussed in this case in tab 6. This is a case about a diver, a personal injury case, and he succeeds against one party in an action in the United States, which I think is settled, and that party then seeks contribution in the Scottish courts. And the passage at the moment I wanted to refer to is on page 88 in the speech of Lord Keith of Kinkell. And just over halfway down, page 88, I won't read all of this, but your Lordships will see that he refers to how the law relating to contribution among co-delinquents stood prior to the passing of the Act of 1940. He refers to the Palmer case, which we've looked at, and then halfway down the paragraph, towards the end of the line, Glasgow Corporation and Turnbull, and then at the end of the paragraph, he reiterates from the speech of Lord Watson and Palmer, the claim of relief rests upon the fact, as Lord Bankton puts it, the use of the claimant's money, the rest have been freed from their obligation, and that then gives rise to the right of relief. And he then says, Section 3 changed the law in a number of ways. First of all, it made it possible, where two or more persons have been convened as defendants in an action seeking damages against them jointly and severally on the ground of wrongful acts or negligence, for their liability inter se for the damages to be apportioned among them in that action. And that's Section 3.1. You sue the defenders looking for a joint and several decree. There can then be apportionment. And then further, it enabled the apportionment to be made not on a pro rata basis, but in such proportions as might seem just. Again, that's 3.1. These changes were a development of the law, as stated in Palmer's case. Then, by subsection 2, a person who had been found liable in damages in an action on similar grounds was given the right to recover a just proportion of the damages he had paid from any other person who, if sued, might also have been held liable for the same loss. This gave statutory force to the law as it had been held to be by Lord Murray. We saw that Lord Murray relied upon Palmer and where the equity comes from, etc. So Lord Keith puts it as giving statutory force to the law as it had been held by Lord Murray, but extended it so as to enable recovery not merely of pro rata contribution, proportion of the damages, but of such contribution thereto as might seem just. So that's a convenient summary, I think, of what Section 3 did, and it's the first part of it is about Section 3.1, and then we get to section 3, subsection 2.
So you said that there's still a requirement for a decree as a condition precedent. Why couldn't you be found liable in the very proceedings in which you're claiming contribution? If the issue is raised as to whether or not you were in fact liable,
Yes.
in relation to the payment that you've made, and you, without any decree, bring an action for contribution, why couldn't you have the two issues resolved simultaneously in those proceedings?
Yeah. I think it's... Yeah.
Do I take it from the first part of what Lord Keith says that up until 1948 you couldn't have... Sorry, Mr.
Sorry, no, it's fine.
You couldn't have actually had a division of the 50-50 in that case. You couldn't. Because he says it made it. First of all, it made it possible where two or more persons be convened defenders. Blah blah blah.
Yeah.
For their liability intersave the damages to be apportioned among them in that action, which suggests, I'm just asking, that up until then, it wouldn't have been possible for the judge to say, well, the total thing is 20,000 to the pursuer, 10 for you and 10 for you. But on the other hand, if you were found joint and several, it went without saying that you would have...
Yes, I think that's right. No, so the first point he makes is that it allows apportionment in the joint and several situation. That's what 3.1 does, and then it enabled it to be made not on a pro rata basis, but in such proportion as might seem just. And he goes on to say that in relation to 3.2 that it is giving statutory force to the position as held in Glasgow Corporation. But in answer to my Lord and the Chair's question, I think one has to look at it. I've been looking at the common law position. Yes. One will see when one turns to the Act, just how the Act deals with the particular point. Your Lordship has
be found liable in any such action.
In any
such action has got to be an action for damages, not for contribution.
That's right. So
there's a distinction too, but in the second paragraph on page 89, or the first complete paragraph, I see he discusses the difference between found liable in section 3.1 and held liable in section 3.2.
Yeah, I was going to come back to that, my Lord, but it's perhaps useful to notice it as we're on it. He seems to be saying here that, well, just reading it, turning now to the first argument for the appellants, the question for resolution is whether on a proper construction of the words found liable in section 3.2, that subsection takes effect only where there's been a judgment of the court on liability and damages in a contested action, or whether it suffices to have been a formal decree of the court giving effect to an agreed settlement. Now, he goes on to hold that the latter formal decree of the court giving effect to a settlement is sufficient for found liable. But the interesting point he makes is that some assistance is, I think, to be gathered from the use of the word found in relation to the liability of the person claiming contribution, in contradistinction to the word held, used in relation to the liability of the person against whom he is claiming it.
I must say, I find that distinction a pretty tenuous one to say you get the answer to the case from that distinction. The answer to the case is no doubt policy-driven. Perfectly sensible result, but to say you get it from that distinction.
Yeah, well, I take my Lord's point, and I don't need this to succeed, as it were. But it's just helpful to notice that Lord Keith appears to take the view that held liable is a stronger and more difficult requirement than merely found liable. Found can simply be giving effect to the settlement. Held has the flavour of there having been a contested litigation and a decision being made on the respective merits of the case.
How do you get your decree of the court procedurally in this situation? In this jurisdiction, one would expect in a personal injury action there to be a letter written before any proceedings are begun, a letter before action.
Yeah.
And if a settlement followed without any proceeding being commenced, and you then say, well, we need a decree before we can claim contribution, how do you get that? You have to
It would have to be brought into
Who would be the
court.
parties to the process by which you got your decree? The injured party and the
The injured party and a defender
person
who is,
who's now paid the claim
who's
without
paid the
proceeding.
claim. Yeah, and but it does create some difficulty in settlements in Scottish cases.
Yeah.
But it's simply
very unsatisfactory that you've got to actually commence legal proceedings to protect yourself.
if you want to use Section 3, subsection 2, because of the language of the provision talking about found liable, etc., on the basis of COMEX, you require to have a decree, and therefore, if you do settle, it can't simply be the usual without without admission of liability, etc. There will have to be a decree to allow you to then operate Section 3, subsection 2.
But presumably, in day-to-day practice, it's in the vast majority of cases where insurers and experienced trade unions and others are involved, defendants know perfectly well how to work the system, and they certainly won't settle without having either got some agreement for contribution from any other person, or else ensuring proceedings are started against them in order to be able to enforce them.
Yeah, that's right. I mean, I've found myself advising on the effect of a settlement and whether or not a decree should be obtained, and this makes it clear that if the right of contribution is to be founded upon Section 3.2 rather than something else, there may well be other ways in which you can recover down the line. You simply say the party down the line breached a duty to you and caused you the loss of having to make the settlement. One is not saying here that in every settlement case, if you want to pass liability down the line, you've got to have a decree. It's simply that if you're seeking to operate as a defender, Section 3.2 and that right of contribution, the way the language of the section is expressed is that you have to have been found liable, and that therefore, on this case, means the formal decree of the court.
And that's because the expression "found liable" means, as stated in a decree or at any rate in a form.
That's what Lord Keith says, and he distinguishes that from held liable, and he seems to be saying that held liable. He doesn't express it fully, but it seems to me that what he's saying is that connotes a situation where there has been a contested litigation, a decision held connotes, I think, a decision being made on the merits of the matter between the parties.
Seems to be of some significance when we come to construe the same expression in subsection 1.
Are you saying that you need to have a decree then that actually expresses the amount for which you're held liable in terms, or you can't just have a decree interponing authority to joint minutes which just simply says that the action has been settled? It has to go that far, does it?
Yeah. My instinctive reaction to that is that one wouldn't need to go the distance of having the decree specify the sum. It is a question of being found liable.
You have to have paid them as a precondition.
Yes. Yeah, sorry.
There must be a finding of something that you can actually pay.
Yeah.
Presumably, you could have found liable for damages to be assessed,
Yeah.
and contributions fixed, and then you go off to an assessment, or they can agree them.
Well, the standard approach would be to probably to have it simply in the joint minute, the agreement settling the action, no actual reference in that necessarily to the particular sum. One can simply have that dealt with.
Sometimes insurers are quite keen not to have the figure disclosed for obvious reasons.
Yes.
Mr. Clark, I recall there was a case from the 1970s where Lord Davidson, who was counsel, I think he was the dean at the time, got heavily criticised by Lord Robertson because he had gone through an enormously long proof simply to establish the liability which he was then going to use in an action of relief. And my recollection is, I can't remember what happened. It went into the division. I mean, I just wondered, did they say anything about? Do you know the case I'm referring to? It was to do with a railway cutting, a railway embankment or something, which had slipped and a whole lot of loss.
Should you have a declared?
That's Junior's reminding me of this, the case where the pursuer was simply put to his proof over some time, and there was criticism certainly in the division, but
Not the same point, is it?
I don't think it's. I don't think it's. I don't think it's quite the same point.
You
No.
could be found liable in damages or expenses merely by a declaration to that effect, or what we would call a declaration, a declarative to that effect, without having the quantum assessed. Would you? I mean, you'd satisfy the section if you did that. Wouldn't you?
Well, I was going to.
Otherwise, you'd have to have, as is just indicated, you'd have to have the quantum assessed in every case, which would be daft.
Yeah.
Not that daftness is always a reason why.
But it may be that I'm best to address that when one looks at the actual wording of the provision, because it does talk about and has paid the particular sum. I'll come to that.
In subsection 2, yes.
Yeah, in subsection 2. So essentially, the first sub-part of the first chapter is simply to say that that is the underlying rationale, and there is, in my submission, no absolute right of contribution, simply because there are others out there that one can say are somehow to blame. The entitlement will arise if the defender can find someone else who, to use Lord Bingham's expression, owes in law the obligation to the defender, and indeed using the expressions from the Scottish cases, where the defender has basically paid the third party's debt and freed him from his obligation. And it seems clear from the cases that that underlying rationale survives. The changes wrought by the provision don't go to the roots of it. I would now move, my lords, to look at the language of the provision. It's in tab 1 of the bundle.
Are we going to get anything out of subsection 3, or are we going to concentrate on subsections 1 and 2?
I was going to look briefly at subsection 3, my lord. If I could look at all of them in turn, but focusing principally on subsection 2. We're just looking at the whole provision. Subsection 1, wherein any action of damages in respect of loss or damage arising from any wrongful acts or negligent acts or omissions, 2 or more persons are, in pursuance of the verdict of a jury or the judgment of a court, found jointly and severally liable in damages or expenses, they shall be liable inter se to contribute such damages or expenses in such proportions as the jury or the court, as the case may deem just. So that's, going back to Comex and Lord Keith, that is the, with a joint and several liability, the court can apportion.
So if they'd both been sued in this action, there would have been no question of contribution. So why should they be better off if one of them is not sued? It's rather paradoxical that, why should Enviroco be better off simply because the charterers weren't sued, and why should the charterers be worse off when they weren't sued than if they had been sued?
Yeah, yes, yeah. Well, that's what one can certainly see it that way, my lord. Yes.
Can I just catch you before you move on? I'm looking at tab 5 in the appendix at the plea looking for contribution at page 38. Just to be sure how that relates to what we're looking at. Is this a plea 5? Is that being directed to section 3, subsection 1? It's tab 5 in the appendix.
Oh, yeah, it's 5, yes.
And it's a plea in law for the defenders.
Where are we? Which?
Page 38, plea in law 5.
Yes. It has been taken to be throughout the proceedings, although it is not in its terms specifying section 3, well, either subsection of section 3.
Sorry, I'm completely lost.
I can't find the page.
Tab 5, top of page
38 at the top of the page.
Oh, I see, sorry.
And it's... If you find that...
Right, I'm sorry.
It's a fairly standard plea.
It is a standard plea. Is it directed to subsection 1? Because both parties are in the same action. And
Well,
Because they're not sued. I mean,
no,
because
they're
the
not- they're
third
not sued by
party is
the
not
pursuer.
joined as a
Yeah.
as a defender.
Indeed, the pursuer hasn't adopted any averments against or made any averments against the third party. So the pursuer is it can't be a Section 3(1) job, as it were, because there is no question of in this action the third party.
So it's a 3-2 plea then?
It must be a 3-2 plea, I think, my Lord. Yes, although it must be seeking contribution. The word apportioned is the only word that's used in relation to the liability, but it has certainly been taken throughout the proceedings to be a Section 3, subsection 2 plea.
Where's the substantive case pleaded?
It's
Against the
it is in answer 5 for the defenders. It begins at page 27. It's quite a lengthy. So that'll just be clear. In fact, I think is it answer 4? Sorry, my lords, it's actually earlier than that. It's in answer 4 for the defenders. That begins, just looking at the pagination in the bundle, page 88. And your lordships will see that the way it's structured is the way the answer is structured is to begin by making a contributory negligence case against the present pursuers. So one sees that just at letter D, above letter D on page 15, the damage to the vessel was caused or in any event materially contributed to by the pursuer's own negligence. And then there's a lengthy set of averments about how the pursuers are said to be responsible for that.
18B.
And
18B, I think.
91, isn't it, about ASCO?
yeah, one gets to
91B.
ASCO at 91, and interestingly, well, the way it's put is that
They have to revert the charter.
Page 1 at the top of the page is
page 91, just about halfway down.
the appendix, which is the page.
Well, in fact, just at letter B on page 91, further explained in the verb, the accident was also materially contributed to by ASCO.
Yes.
And what one actually sees after that, just to give a couple of examples, just at letter C and then again at D, and indeed at the bottom of the page, the way it's put is, like the pursuers, ASCO knew, like the pursuers, they knew, like the pursuers. One actually sees that expression.
Is the duty of
It
where is the duty?
Yes, page 93.
Yes, 93. It's the duty of ASCO.
yeah.
Yes.
Yeah, there's the duty to give the order to shift berths at such time that the vessel's into. That's introduced by a separatum. That's a separate point. But what had been done in the pleadings for the
Toolbox talk.
for the pursuers in the case, just at page 88 between B and C, because it wasn't clear from these averments whether, for example, a duty of reasonable care was being averred, and indeed to whom it was contended that such duties were owed. This call is put into the pleadings. The defendants are called upon to specify whether duties they aver are duties of reasonable care, and to whom it's contended they were owed by the third party. And that isn't really answered in any detail, but it has been taken for the purposes of the discussion in the case so far that
92E, isn't it? Some of it, you know. Duty of ASCO as charter and base operator to be present in toolbox talk and all that
yeah,
stuff. Charter,
duty to be in attendance at that. Yeah. And
separate.
again, I think that mirrors the case against the pursuers, the contributory negligence case against the pursuers, as I understand it. But
What there isn't is an averment of any liability on the part of ASCO's case, not an express one. But is there a reply to this saying ASCO is not liable?
It's quite outre denied, actually.
yeah, I think it's just a denial of those averments, and then it's simply focused by denying, I suppose, the existence of the duties which are contended for, and that's obviously one of the points that I'm seeking to raise in the course of this appeal as to whether, standing the terms of the contract, any of these duties were owed by the third party.
I think Lord Hodge makes this point in paragraph 2 of his judgment,
He does.
where he says, although it's not expressly averred, the pleadings imply that the third party failed in its duty to the pursuers, and he proceeds on that basis.
Right. Your Lordship is absolutely right. He proceeds on that basis.
have taken no part in this at all, have they, or have they?
They were convened as third parties. In the commercial court in Scotland, there are regular preliminary hearings, and at those hearings there's discussion of how there's extensive case management and discussion.
So we have a third party.
Yes, we do, my Lord, yes.
Where is that?
It is after each answer for the defenders, there will be an answer for the third parties.
Yes, at the bottom of 93.
Yeah, bottom of 93. They
Just deny everything.
yeah, the third party doesn't admit owing any duty of care to anybody in the case.
Without to deny.
They don't seem to be very helpful in identifying present issues, but we seem to have got that.
No, I think that's right. Well, it's partly because of the way in which there is this extensive case management of these cases.
Yeah,
One can simply discuss them quite fully in the preliminary hearings. And what happened was that the third party said, basically, we don't need to take part in the debate because it's really it's the same point, so we'll fall out of it. But for what it's worth, in the pleadings, they admit duties of care being incumbent upon the pursuers and the defenders, and it would seem by implication that they're at least potentially denying duties of care being owed by them to anyone.
Well, they've got pleas at page 111, pleas to the relevancy, which provide a vehicle for disposing of the argument.
Yes. I mean, this certainly isn't a case in which the third party is saying, fair enough, I am liable to the defenders. His pleas in law simply don't reflect it.
Said, well, don't darken our doors.
Yeah.
Send all your allegations to the shipowners.
Yeah, yeah, but they have a plea to the relevancy of you have a plea saying that the averments anent about the fault and negligence of the third party being irrelevant et separatum, lacking in specification. They shouldn't go to proof, basically.
And also plea 2.
Plea 2 in relation to apportionment. So,
What does irrelevant mean in that context?
simply would give rise to no remedy in law. Don't suffice to give rise to a legally relevant case.
No case to answer.
So that would be sufficient to challenge the alleged duty of care.
Yeah.
Oh, yeah.
Well, they say that in terms, the defence of averments anent the fault and negligence. That would challenge the duty. And then plea 2 seems to challenge the whole question of, again, it mentions apportionment, but it's the contribution case I would understand to be challenged by plea 2.
It's rather. At what point is it that someone says, actually, the reason I'm not under any duty, or the reason I'm not under any liability, which is the material thing, is that there's a clause in the Charter? Is everyone taken to know that, or is that
Plea
drawn to attention?
Plea 6 of the third party does refer to indemnity.
Yeah.
Page 112.
Yeah. Yes, as to any liability
Yes, I see.
is apportioned. Yeah.
Yes, but and that's the indemnity. But I mean, their basic point is under 2, presumably.
It's dealt
Look
with.
at the Charter, look at clause 33, and we're out.
Well, in fairness, my learned friend points out, it is in fact expressed a bit more fully on page 107 of the bundle.
Oh yes, well there it is.
So they set it out there. They say
that's
it's
the whole thing,
33.5, and we're the way they put it is we're entitled to be indemnified. That's how it's put. But effectively, it's we're out of it.
And what the Lord Ordinary did was to sustain the first plea in law. Because, as he puts it, the pursuers did not have a right to obtain damages against the third party in relation to the damage referred to.
Yeah. That's right, my lord. But it may be that there could have been some issue about whether the second plea in law should also have been sustained. But it was sufficient to dispose of the case. deal with it simply by sustaining the first plea.
But he did that on the basis of his analysis of the clause.
Yes.
And the section.
And the section, yeah.
Not saying anything in relation to the duty of care.
He doesn't deal with it in those terms. He doesn't say there's simply no duty at all owed by the third party to the pursuers, but he simply says that standing in terms of the provision, you have to have the third party, or you have to envisage an action in which I sue the third party, and the third party is held liable, essentially in damages to me. And he says, well, that can't happen, standing the terms of 33.5.
The phrase he uses is that they did not have a right to obtain damages.
Yeah.
That's really the crucial point on
that's the crucial
his
point.
view.
That's at the very heart of the case. If clause 33.5 does not give the pursuers the right to obtain, or results in the pursuers not being prevented from holding the third party liable in damages, then essentially the section cannot be satisfied, and the claim therefore falls away. And accordingly, it's really, while there are the two chapters, there's the Act and the contract. Clearly, it's the contract is at the heart of the case.
Is there any authority on the position of an exceptions clause which doesn't exclude liability completely, but reduces it to, say, £500? Contribution is claimed, and the court then has to decide what contribution is fair and reasonable. Is there any authority that the court would take into account in holding the contributing party liable for contribution the amount of the limit under the exception clause?
Yeah. I haven't found any, but I don't think either of us or any of us has found any on that.
It's rather curious. I mean, you're potentially liable to contribute on your case if there's any liability, even if it's severely limited.
If it's severely limited.
It may be the court would limit the contribution by reference to the clause.
Yeah,
yes.
I would have thought similar. I think
yes.
And that fits with the cooperative retail services case.
It would be if sued to that extent, they're liable.
Yeah.
Monstrous otherwise.
Yes, yes. I'll come back to that in the context of the case, but just if I could just turn to the provision. I was about to look at section 3, subsection 2, and the way it's put is, where any person has paid any damages or expenses in which he has been found liable in any such action as aforesaid, he should be entitled to recover from any other person who, if sued, might also have been held liable in respect of the loss or damage on which the action was founded, such contribution, if any, as the court may deem just. Now, this, of course, is enacted in 1940, and your Lordships will have seen in tab 25 of the bundle, I don't need to look at the detail of it, but the third-party procedure in Scots law was introduced in 1963.
Well, it had been in existence before that. It had been in existence at some point. I can't remember the detail, but it had been in existence, if I recall rightly, in the 30s, and then was removed.
It was removed, yes. Certainly, when one sees the 1959, I think it's the National Coal Board case, the absence of a procedure in 1959 is bemoaned, and that seems to be the immediate catalyst for coming in 1963. But that I think explains the tense, at least, in 3.2. Section 3.2 is, as I understand it, working on the basis that there is action 1, as it were, where the injured person sues one of them, and then where any person has paid any damages or expenses in which has been found liable in any such action, he shall be entitled to recover from any other person, etc. And it's assuming, I think, at this stage will then be action 2, but of course, after the third-party procedure is reintroduced, one then finds that you simply do it in the same action, and that's what's going on in the present case. But just looking at the language of any such action as aforesaid, and then the reference in the third line to on which the action was founded, that can only be a reference back to 3.1 and therefore to an action of damages. in respect of loss or damage, etc.
And found liable or held liable refer to a liability to the injured party, obviously.
Yes.
And that's a common link.
Yes. Yes. That must be right, my lord, yes. So one is looking for a circumstance in which a person has been found liable in an action of damages in respect of loss or damage arising from any wrongful acts or negligent acts or omissions. And he is then entitled to recover from any other person who, if sued, and I think it's common ground, that must mean if sued by the injured party, I think that's the agreed position, might also have been held liable in respect of the loss or damage on which the action was founded. That's pretty close to the same damage point in the 1978 Act in England.
And what does might indicate, if anything?
Yeah. Well,
is that the same as would, or would if sued? There is a case which I think, or at least there are some dicta which do focus on that, I think. I can't remember which case.
That's right, Murad. It's in, well, I think the best place to find it is it's in the opinion of Lord McCluskey in one of the cases. I think I'll just go to that. It's in the Dormer case in tab 10. And just again using the pagination in the bundle, page 119. And it's the second complete paragraph on that page, beginning, while I do not read this, he says, while I do not read this as being part of the ratio of the decision, it is powerful support for the view which, in my opinion, the odd reading of the word suggests. In the present case, if the third parties have been relevantly, competently and timelessly sued by the pursuer, as the defenders themselves were, then obviously the defenders would have had a right of contribution against them under subsection 1. As I read it, subsection 2 confers the same right if the third parties would have been held liable had they been relevantly, competently and timelessly sued. The change in my formulation from might to would is deliberate. It recognises the fact that a third person may be made liable to contribute if the court concludes that he would have been found liable if he had been relevantly, competently and timelessly sued. These two concepts are rolled up into might have been in subsection 2. I don't know whether that's the passage you lost in mind.
I think it was, yes, thank you.
So it is simply that that expression carries with it the idea of had he been relevantly, competently and timelessly sued, and the thing been done properly, effectively and in time.
Tested what, as at the time of the first action or the first putative action?
Well, that I think is not finally settled in Scots law. The Lord Ordinary deals with that in his opinion.
Because in England it says would if sued have been liable, doesn't it?
What is the reference where it says the change in my formulation from might to would? Yes, I see. Yes.
Yeah, it's my formulation. Yeah, it's his formulation of might to would. But I think what it comes to is that, as I understand it, the might is simply there to carry with it the need to do it properly, relevantly, competently, and timelessly, and it comes to this. It comes to the point that he would have been found liable in this action. And just turning back to the language. So we looked at such action, etc., and if sued, as I've said, means if sued by the injured party. There's then the question of held liable, etc., and whether if sued means basically if sued for judgment. There's some discussion of that in the cases. In tab 19, in the Singer case, this may well be common ground. I think this features in, perhaps not this particular reference, but I think the point features in the respondent's written case. This is about, the Singer case is about abandonment by the pursuer against the defender, and then whether or not if another defender tries to bring him back in as a third party, the act of abandoning the claim by the pursuer has cut off the right. And just looking at what was held in about the middle of the first page on 247, Section 3.2 of the 1940 Act did not put it into the hands of the pursuer at his whim to defeat the rights of a person to obtain relief against a joint wrongdoer. The words "if sued" in that subsection being properly construed as "if sued to judgment." And the Travers case is overruled. And over on page 249, just a little more discussion of the point. In the first substantial paragraph, just about halfway down towards the end, well, at the end of the line, as a matter of pure construction, we have little difficulty in concluding the words "if sued" in section 3, subsection 2 means sued to judgment, i.e. sued to the point at which there has been a judicial determination of liability. That is, in our opinion, the effect of the words. Here they say found liable or held liable within the meaning of the decision in the English case of George Wimpey. And of course, we saw in COMEX that later there was that distinction drawn between them. But the Inner House here is saying sued to judgment, and that does seem to be how Lord Keith of Kinkell was dealing with the matter in the COMEX case. So, and in fact, we'd looked at that. I was going to go back to, perhaps I could just remind your Lordships of precisely how Lord Keith dealt with it. Is it page 89 of the bundle in tab 6? Maybe no need to go back over this, but in the first substantial paragraph on page 89, that's where he discusses the
Sorry,
found...
which tab are we on?
Sorry, no, tab 6. This is where he's discussing whether found liable, as he says just in this first substantial paragraph on page 89. Turning now to the first argument for the appellants, the question for resolution is whether on a proper construction of the words found liable, that subsection takes effect only where there's been a judgment of the court on liability and damages in a contested action, or whether it suffices there's been a formal decree of the court giving effect to an agreed settlement. Some assistance, and he then makes the distinction. It's found in relation to the liability of the person claiming contribution in contradistinction to the word held, used in relation to the liability of the person against whom he is claiming it. And he refers back to found liable in subsection 1, and basically if they're given a particular meaning there, they should have the same meaning in subsection 2. So what we have then is that the test in section 3.2 is looking for a circumstance in which if the third party had been sued by the pursuer in an action of damages, he would have been sued to judgment. He would have been held liable. So, plainly, if the court, and if the Lord Ordinary is right, the language of the Charter Party prevented the third party from being held liable in such an action, then the subsection simply isn't satisfied. And the word liable in my submission simply takes us back to the common law underlying rationale. It presupposes some underlying obligation or liability on the part of the third party to the pursuer. There is then the question of what the liability would consist of. And in my submission, the ordinary and natural meaning of the words liable in respect of the loss or damage is subject to an obligation to make reparation in respect of the loss or damage. Effectively, that it is a liability in damages one is looking to be established here.
Let's take one back to subsection 1,
Yes.
which casts, as it were, light as to what subsection 2 is talking
Absolutely.
about, because it does say liable in damages or expenses.
Yes.
I mean, even expenses would be covered, I suppose, in subsection 1 and in 2 as well.
Yes. No, I think that is right. Liability and damages or expenses, yes. But it's looking for an action of damages by pursuer against third party, and that the third party would have been held liable in that action if sued to judgment. The decision of the court on the contested positions of the parties would have been that the third party was liable, and they're liable in damages or expenses to the pursuer.
Would expenses that, sorry, expenses there just being what we would call costs in England?
Yes.
I mean, does the third party, or can he in an action, if sued in this action, say, well, yeah, you can see the thing, or I can bring in extra evidence which shows that that the part of the claim was bad. I wouldn't have been found liable for part.
Yes.
I can do that.
Yes, you can do that, yes. Yes, I mean, the...
Yes, the underlying claim.
Yeah.
So, I mean, I've been found liable for 10,000. He can say, well, at most you should have been found liable for 2.
Yeah.
Is that right?
Can he do that?
That's what I'm asking.
It's not obvious to me that he can do that.
That's not-
Well,
He doesn't get another go.
yeah, it may... yeah,
Well,
he hasn't. He's not been in. He's not.
I think it must result in being held liable, a decree that he is liable in damages or expenses, and
The word any appears, doesn't it? Is that any help? In subsection 2.
I suppose he could say, well, I wouldn't have been held liable for £1 million because I had a particularly good point, which for some reason...
I haven't quite got the hypothesis. I mean, he's not party to the original proceedings.
No, it's not part of the
So,
yeah.
No.
well, on that basis, he can take any point
Take any point.
about his
It's open
own
to-
liability.
Yeah,
Yes.
yeah, yeah.
Yes. It doesn't matter what somebody else has said in other proceedings.
Yeah, so when it comes to the defender directing his claim against the third party, he can simply take whatever is open to him. And in the ordinary case, or in a case not like this, he wouldn't have the indemnity aspect of 33.5, and he would therefore...
Quite.
He would run every point he could, reasonably open to him.
Would that bear on the amount of the contribution, then? Because that's the way of sorting this all out.
Yeah, that's how it's
really.
sorted. It would. Yes, it would be when the court comes to make such contribution, if any, as the court may deem just. It would give effect to those arguments at that stage. I mean, if he...
Well, I mean, if they're only liable for the same damage to the extent of, say, £500,000, the chap who sued first is liable for £1 million, but there's a commonality of damage as to 500,000.
Yes.
That would clearly affect the amount of contribution you could seek.
Yes. Well, I think it would have to, in my
You'd just be looking at the 500,000 which they shared in common, and then
Yes.
trying to assess their
Indeed.
respective responsibility.
In relation to that, yes,
Yes.
indeed. It would simply be yet another example, and I think that's really the nub of the point which the appellants make here, that defences open to the third party, regard must be had to those defences. And if it's a complete defence, then it's an end to it. It cuts off the possibility of contribution. There may be other defences which result in a lesser award against the third party, or a limitation to a particular amount. And at the contribution stage, as my Lord Hope mentions, that the court can then give effect to that. But if what one has is a case like this, where if we are right about the construction of the charter party, it simply prevents him succeeding at all, then we don't get into the apportionment issue at all. Lord Hope mentioned section 3, subsection 3, and it is, I think, helpful just to notice it. It says nothing in this section shall A, and that's just about timing, B, affect any contractual or other right of relief or indemnity, or render enforceable any agreement for indemnity which could not have been enforced if this action had not been enacted. And my broad observation on that is that, in my submission, it is effectively simply saying that contractual rights are not being overridden by this provision. It is, in my submission, recognising that parties by contract may well allocate their respective risks and liabilities, and this section isn't seeking to touch what the parties themselves might have done in that regard.
It looks at, it's very broadly expressed, so
Very
it could
broadly
deal with indemnities for any of the three parties who are involved here. Could
Yes.
it? Just simply you ignore them for the purposes of the, well, they're not affected by by the statutory remedy.
Yeah. Yeah. It is very broadly expressed. So,
Well, it must take it to exclude whatever else is meant by the other right of relief. It can't refer to the common law right of relief 50-50 apportionment.
yeah, I think I must be right, my Lord, yes.
Because otherwise the scheme wouldn't work.
There would be no point in the statutory scheme. Yeah.
So have you got a suggestion as to what the other rights of relief are, Mr. Clark?
Yes.
Was that one of these nasty questions which you didn't
Well,
I find the whole of it will be a little bit puzzling, because it ends up which could not have been enforced if this section had not been enacted. So it's really saying this section is not to give rise to
Yes.
such a right.
yeah.
An enforceable agreement for indemnity.
Well, the other side might say, well, it preserves the Charterer's right of indemnity against you.
Yes.
Yes.
Sure, there's a comma after the word indemnity in the first line, isn't there? That's the end of the first thought, isn't it? Mm-hmm. So it doesn't undermine any positive contractual.
Yes, I see.
Yes, I think so.
Yeah.
It doesn't create anything new.
After indemnity in the first line. It's an invisible, yes, it's an invisible comma.
Yes.
An invisible.
Yes. Yeah.
I wondered
Yeah.
about that.
There is another of those in a criminal statute we came across it, well known in the criminal courts as the invisible comma.
I see. Right. Yeah. Yeah, I mean, the other right of relief, Merlin Junior gives the example of in a vicarious liability context, there would be the right of relief for the employer who's sued in that context. And I think it's simply saying that simply saying that it's not.
That's contractual, I think, isn't it? Sort of. It's the case, this cold storage company case.
Yes, Romford against
Lister and Romford Ice.
Yeah, Lister against the Romford Ice and Cold Storage Company. Yeah, that's right. Well, that's one possible example. But I think I read it as simply preserving private contractual arrangements effectively, and not overriding them. That's what my submission on it would come to.
Are there two invisible commas?
There might be a partnership rights of relief, might there, in equity, I suppose. Mm-hmm. If an innocent partner is held liable to contribute.
Mm-hmm. Mm-hmm.
I was just wondering just how one construes this. Is there a second invisible comma after indemnity in the second line of B, or not? And just simply reads that
No, I think
from
it's
or as a single part.
I think the break is after the first indemnity.
Yes. So the last part qualifies the word enforceable.
Yes, enforceable, my Lord. Yes, I think that must be right.
I mean,
Qualifies
it's a kind of indemnity against criminal liability or something like that. Is that right? That could not have been enforced. Because I mean, you can't. If you commit a criminal offence, you can't have a right of indemnity. And therefore, what this is saying is, in that situation, when it wouldn't have otherwise been enforceable, this doesn't make it enforceable.
Doesn't make it enforceable, yeah. So there is the break after the first indemnity. There is the invisible comma there. It's saying two things. It doesn't affect any contractual or other right of relief or indemnity, and it doesn't render enforceable any hitherto unenforceable contractual rights of relief or indemnity. And the example might well be the point my Lord Roger makes.
I just wonder what that first bit is looking at? Is it really effectively saying that the fact that the statutory remedy exists doesn't deprive B of any contractual or other right of relief or indemnity he might have against C or some other party, but it's not really looking at C's position at all? That
No.
might be the argument against you, that it's really looking at B, who's seeking some kind of indemnity or relief, and his contractual position, if he has any, isn't affected by that. But
Yes,
does it
if-
tell one anything
yeah,
about C's position?
Well, if in this case the defender, Enviroco, which, as we understand it, I think it's clear from the averments, had a contract with the third party, if that contract had contained a contractual right of relief or indemnity, it is unaffected by this provision.
Yes, might have given him a better result than he would have got under subsection
Yeah.
3.
I mean, yes, and it's certainly part of the appellant's position that in this whole offshore industry area, where there are all these mutual indemnities, that it would have been open to the defenders to seek to have such a contractual right of relief in the contract.
And the likely position would have been that would have been 100% indemnification,
Yeah.
as opposed to proportion, which is all you would get under subsection 2.
Yeah, that's right.
So, I mean, you could get a better result
could get a
under
better
the
result.
contract, and that is preserved.
That's
But
preserved.
I mean, that certainly means it has some significance so far as the defender is concerned. But does it tell one anything about the third party C and his or its right of indemnity? Is it really dealing with that problem of the indemnity which the pursuer has given to C? I'm not sure it's really thinking that far ahead, actually.
But it's, yeah, the language is general. I think that's part of the difficulty. But my reading of it is really the former of the two situations my Lord puts forward. That it is well, it's certainly not clear to me that it is looking that far ahead. That it is dealing with the position of the pursuer in this case. I think it's effectively saying. It's really about the rights between B and C, and I think it's effectively speaking of rights between those parties. So if B has managed to obtain a contractual right against C, then it is not rendered something which would give rise to apportionment under the Act. It's just left to have its full force and effect according to the language of the contract.
Here there was a contract, on the facts there was a contract between the contractor and the charterers, is that right?
Yes.
But we don't have details of that, do?
We don't have details. We don't even know whether it was a purely oral contract or whether it was in writing.
Nobody's pleaded it.
Nobody's pleaded it. No document has been produced saying what it is. I think we know, well, by inference, we would understand that there isn't any contractual right of relief in there. But it's never been made part of the case. Yeah. So, what it comes to is that the test of liability under Section 3, subsection 2, is whether if the appellants, the pursuer, had brought an action for damages against the third party, that action would have succeeded on its merits, with the result that the third party was held liable in damages or expenses in respect of the loss or damage to the vessel. And if the third party would have had a complete defence to such a claim, then the claim for contribution must fail. And
I mean, that's the same question as under subsection 1.
yeah, I think it ultimately
Precisely the same question.
it comes to the same question, my Lord. Yes, the question of whether or not one could have found.
And I'm right in saying this whole question can be determined by simply assuming the action was by the ship owners against both parties as defendants, and seeing what the position was then as between the pursuer.
As presently advised, it doesn't seem to me to make any difference. One could simply look at it that way, because it's the same point. Had we had the third party as defenders in the action, had the pursuers sued both, would it have been possible, standing 33.5 in the Charter Party, to find the third party jointly and severally liable?
It must be. They must run in parallel, mustn't it? It is an integral part of your argument, because there would be no logic in their being separate or different rights of contribution in the two situations. Indeed,
right.
it would be very bizarre if there were.
No, that must be right, my Lord, yes, that must be right.
Hence the reference to any such action as aforesaid, really, in subsection 2.
Yeah.
So, I mean, we've got a simple,
Simple point.
on your case, we've got a simple scenario, and you simply say that there's no authority which excludes a contractual exclusion from that scenario, or says that that's different. It's a way of either establishing or removing liability, and here it removes it.
Here it removes it, yeah.
The effect of the indemnity, as far as you're concerned, is that we're in subsection 2, because you wouldn't dream of suing the third party because it exists. It would be absurd to do that and just be driven back by a plea to the relevancy.
Yeah. That's absolutely correct, my Lord, yes. We would simply have the third party, if convened as a defender, saying, well, implement 33.5 and defend us against your own claim against us, and we'd be down that, what I will characterise as rather absurd route. So it would never have been sensible for the pursuers to convene the third party as a defender in the action.
Well, that then leads us on to the second limb of the argument.
It does, my Lord, but perhaps just before I get there, there's just to touch on the third subpart briefly, which is I suppose the question of principle, whether the pursuer and the third party can, by their contract, affect the defender's claim for contribution. There is the cooperative retail services case, which is in tab 7 of the bundle. And it's perhaps helpful just to look at the rubric at the top of the page. A damages contribution entitlement. Contractors required by building contract to insure under joint names policy covering themselves, building owner and subcontractors against all risks including fire. Building owner claiming damages against defendants, architects and engineers. So the owner sues the architects and engineers. There's this joint names policy covering the building owner and the subcontractors. There's fire damage to the works. Whether effective provisions to eliminate liability as between joint names for compensation in event of fire, whether contractors liable to make contribution to defendants. In short, the central point is whether the contractual scheme between, using the language of the present case, the pursuer and the third parties was such as to eliminate liability as between them, thereby defeating the right to contribution. And just looking at what was held, dismissing the appeal that having regard to the purpose of the all risks policy to provide funding for the reinstatement of the works, whatever the cause of the fire, the effect of the contractual scheme was to eliminate the ordinary rules of compensation for negligence and breach of contract, so that the building owner could not claim compensation from the contractors, but could only require them to carry out the reinstatement works and authorise the release of the insurance monies for payment. And the contractors could not claim compensation from the building owners, but could only require that the insurance monies were paid. And that accordingly, since W Limited, that's effectively the third party, and by party of reason, the W Limited, W are the contractors, H Limited are the electrical subcontractors. Accordingly, that since W Limited and by party of reasoning H Limited were not persons from whom the building owner was entitled to recover compensation within the meaning of section 6.1, they were not liable under section 1.1 in respect of the fire damage as persons from whom the defendants could seek contribution. So, just using the language of how it's put here, if the contractual scheme between pursuer and third party eliminates the ordinary rules of compensation, then the third party is not someone who might have been held liable to the pursuer, and therefore the contribution claim fails. Now, the speech of Lord Bingham of Cornhill discusses matters in relatively broad terms. The detail, I think, is found in the later speeches. We're just looking at Lord Bingham's speech, first of all, at page 94 in the bundle.
So what is the proposition we're going to get from all this, Mr.
Well,
Clark, so as I know what I'm looking for?
The proposition from this case is simply that the pursuer and the third party, by their contract, can eliminate liability, can remove or can.
Authority of the proposition, you can agree what you like.
You can agree what you like, and you can prevent, or you can, but in particular, you can prevent the pursuer being able to recover from the third party, and that will therefore disqualify the claim for contribution. And it is. There are differences in the language of the statute, but I say that there's nothing in substance differing between this case and the present case. The question will be whether clause 33.5 of the Charter Party comes up to the mark of preventing the pursuer from recovering against the third party. But if it does, this case says in terms, and Lord Bingham discusses the policy point, the alleged inequity. This case says in terms that the contract between A and C can result in a situation where B is unable to obtain a contribution from C simply because of the terms of that contract.
It all fell on the insurers of the architects and engineers,
Yeah.
And nothing could be passed back in effect to the insurers of the contractors, because they'd got a block policy which covered everyone under their umbrella.
That's right.
Yeah.
And there were also issues raised in the case about whether a right of subrogation existed on the part of the insurer who had paid to sue one of the other parties covered by the joint names insurance. And Lord Bingham describes that as being absurd. Lord Hope deals with it slightly differently. But again, that's another chapter. But that is relevant in my submission.
Well, that's the Petropina and Magna case, isn't it? Which is cited in the heading.
Yeah. But so there are really 2 points in it. But the main point is simply the principle that A and C can structure their contractual affairs such that A will not be able to hold C liable. And if that's the position, then B cannot claim contribution from C. The contractual scheme is obviously significantly different here. Well, it's a different contract, but the basic point is still there. But just looking at Lord Bingham at page 94 in probably just best looking at the end of the end of the first incomplete paragraph, the first paragraph on the page. It just says in the halfway along the second last line, the issue is whether Wimpey and Hall, that's the third parties, are liable to CRS, the plaintiffs, because if they are not, they cannot be called upon to contribute. And that is the nub of the point. And he says in paragraph 3, in the ordinary way, and in the absence of any contractual exemption or limitation or statutory immunity, a party who breaches a contract or commits a tort is liable to that other. Where there are multiple breaches, many parties may be liable. The 1978 Act provides, in the cases to which it applies, for the sharing of common liabilities. Our Code of Civil Procedure designed to enable claims to be made, etc. And then in paragraph 4, it is however open to contracting parties subject to certain statutory constraints, no doubt Unfair Contract Terms Act and that kind of thing, to vary by agreement the ordinary rules which impose legal liability for breaches of contract or tortious acts on those responsible for committing them.
Does that first sentence assume that one's dealing simply with the parties to that contract? This is a point that Lord Carlaway makes, I think, in his opinion of paragraph 52. He says, well, this is all very well, but this is regulation between the contracting parties inter se, and one doesn't have that here because ASCO and the contractor were not parties to the same contract.
I take the Lord's point. My reading of it is that the contracting parties, that expression as used in paragraph 4, really does mean it could in an appropriate case include everyone if everyone is tied into the same contractual scheme, but it also at least means if simply pursuer and third party have varied by agreement in the ordinary rules which impose legal liability for breaches of contract, that will be enough in my submission.
So if I agree with you that I won't sue you for any breach,
Yeah,
that's enough.
that's enough. Yeah.
And that deprives a party, somebody who wasn't a party to that agreement at all and didn't know anything about it, of the right of relief.
Yeah. Well,
It begs the question as to whether there's any right to relief in the first place.
Exactly so, my lord.
It doesn't
Yes.
deprive him of it. It prevents the condition precedent to his having the right.
Well, if I could respectfully adopt my lord and the chair's observation, then I think that's what it's about. It is not, and it's a question to some extent of perspective. The defender wrongdoer turns up and says, I've committed a wrong. I would ordinarily be fully liable for that. There's someone else who I think I can blame for that. And you're taking away my right of relief. But the point is, one doesn't get to the condition which needs to be satisfied for the right of relief to be there, isn't satisfied because the third party is not a person who, if sued by me, might have been held liable.
Well, that's why it's so helpful to look at subsection 1, because
yeah,
It's all
it's
a
so
bit
clear.
I mean, it's all a bit artificial, this, actually, because the underlying scheme, according to the underlying scheme, you probably shouldn't have a claim against Enviroco at all. That's what they're alleging in the English proceedings, because the underlying scheme, I think, on your own case, is that there are two blocks of people. They each answer for their own loss, and they each have insurance to cover it. It's a classic
not for
French
not.
and therefore Enviroco should be under ASCO's shield, and it's only by happen chance that you're able, it appears, to argue that they're not, because they may no longer technically be an affiliate. That's the English piece of litigation. But for that oddity, that the blank shares have been pledged to the RBS or whoever, that argument wouldn't arise, and they would clearly be entitled to the benefit of, subject to finding some way of enforcing it, perhaps the Himalaya clause argument, they'd clearly be entitled to the benefit of the exemption in the Charter. So it's all very curious, this.
Yeah, well, no, I do take my lord's point. It certainly, when one looks at, when one sees in the very next sentence here that there's reference to the Caledonia North Sea case, and I'll come to look at the.
Can I just go back to the point? Can I just so I'm quite clear in exactly what you're saying? If supposing I've got no agreement with you, and you and somebody else jointly cause loss to me, and then I agree not to sue you after the loss has occurred, is that all right? What happens in that situation?
That would seem to fall within the expression which the Scottish courts have used, for example, in relation to where I abandon against you. I mean, if that's equivalent to agreeing not to proceed against you, the Scottish courts say that is what we call the whim of the pursuer, which is cutting off the already.
But if I have my whim before the thing, then you say that works.
Yeah, because exactly so, Maud. What I say is that in that situation, I am not in the contract already subsisting situation, which is what we have here and what we had in the CRS case. I am not depriving you of an existing right that you might otherwise have, whereas in the other situation, you on the face of it would have the right to seek contribution, and I am after the event interfering with that right.
So does that mean that you test the matter at the date of the accident?
Yes.
As far as the party seeking contribution is concerned, he can say, well, look at the position as at the date of the accident. There was no question of exclusion or the exercise of whim or otherwise. It was open ground. We were both equally exposed to the risk of liability for delictual wrongs and so on, and therefore that should apply. But as soon as that stage is passed, then the position can't be changed. Is that right? By whim?
Yeah.
By whether it's really probably comes to the same thing, abandoning action after it's started, or not raising an action at all because you say, well, I'm not going to insist on my right to claim at all, and so on.
Doing anything, allowing time bar to pass, abandoning, contracting with that party. But the policy point, my submission made clear by the CRS case, is that if one has the pre-existing contractual arrangement that the pursuer will not be able to pursue the third party, then you simply don't satisfy the precondition, and you don't satisfy the plain language of the statute. It is no longer a situation in which, if sued by me, I could have held him liable. That's the language of the statute is simple, straightforward. It doesn't carry with it any suggestion. It doesn't have anything in it saying, "Oh, subject to, if you've agreed otherwise, then that's going to be disregarded in some way." It doesn't try to carve out.
Presumably, the rationale is that this is part of the ground. This is the contractual scheme which the parties could actually investigate before they get involved.
Yeah,
it's a given. It's commercially negotiated, whatever it is, subject to, obviously, perhaps to any Unfair Contract Terms Act in some context, but it's given. And if, in theory, Enviroco could have and probably did know what the basic contractual scheme was, and may well have relied on being an affiliate to protect them.
That may well be absolutely correct. That when one looks at the cases on this, one sees that they're described as knock-for-knock arrangements, and the idea is that not only will principal parties in a North Sea venture have these mutual hold harmless clauses, but that everyone else involved will tie into it. And Rod is absolutely right that it may be that it's the other action in this case which is perhaps it's important in relation to whether or not the third party was in fact tied into that mutual hold harmless scheme by virtue of being an affiliate. That's the point to come.
But I mean, the principle applies whether the third party is or is not contractually involved in the adventure. It might have been somebody just driving along the jetty in a dumper truck or something who had nothing to do with it.
Yeah, exactly. Well, one sees that point is actually discussed by Lord Bingham. What he says is that the parties can vary by contract, the ordinary rules. The House recently had occasion to consider such a scheme in the Caledonia North Sea case, and I'll come back to that.
Is it whether the question is whether or not the defenders are tied into the scheme?
Yes, I think my Lord is right about that. Sorry, I think I'd said third party.
Yes.
Yeah, the question
Sorry,
I'd confused matters. The question would be whether Enviroco are tied into the scheme. But when we look at the scheme in the cases, and the basic idea is that, the underlying commercial approach is that everyone tries to get the benefit of these hold harmless clauses and to bear one's own risk, and that might ultimately be the key question in this case. And it's really a question for the other case rather than this one, as to whether or not Enviroco have managed to get themselves into that scheme. I think that's right. But standing that that's not part of this case, one is left simply to say, if you have a contract between pursuer and third party which prevents the pursuer suing the third party, does that cut off the possibility of a right of relief coming into place rather than interfere with an existing right of relief? And my submission in this case makes it clear, and indeed the policy issues are discussed. The point Rod mentioned about whether the third parties would, whether the defenders would know about the scheme and the apparent inequity of impacting on them. I'll come to that just in a moment, but perhaps just to get there. Basically, Lord Bingham says in paragraph 4, the question is really whether the parties in this case, and indeed just to take the point my Lord Hope made about whether it's all the parties, including the defender, or just in this case plaintiff and third party. Paragraph 4, he says the parties can vary, refers to Caledonia North Sea, and says that where the parties, in accordance with the prevailing practice in the offshore oil industry, agreed that liability for death or personal injury should in general be borne by the employer of the victim, whether or not the employer had broken its contract with the victim or committed any tortious act. And then Mark Rowland's another scheme. In the present case, it is said, CRS had agreed with Wimpey and Hall, plaintiffs and third parties, that in a contingency such as is assumed to have arisen, it should not be entitled to recover compensation from them, with the result that they are not liable in respect of the damage suffered by CRS, and TYP and HLP, that's the defendants in the action, cannot accordingly recover contributions from them. Two main questions arise. One is the contingency which, on the assumed facts, has arisen, one for which CRS, Wimpey and Hall have made express provision in the contracts. So he's simply saying, have the plaintiffs and the third parties made express provision for this in their contracts? If so, what is the effect of that provision? Sorry, is the effect of that provision to preclude, on the assumed facts, a claim for compensation by CRS against Wimpey or Hall? And he goes on to deal with that. Just in the last sentence of paragraph 6, he discusses the contractual scheme, and he says, but it plainly precluded any claim for compensation by CRS against Wimpey or a subcontractor such as Hall. Their duty was to make good, not to compensate. And the policy issues are to some extent discussed in paragraph 10 over the page on page 95. TYP and HLP, the defendants, complain with some force that the conclusion expressed above may lead to a very inequitable result, the bearing of the entire financial consequences of a catastrophe by a party who may have had a very minor responsibility for causing it. This is indeed a possible outcome, and may be the case here. But this is the effect of the standard form contract which CRS, Wimpey and Hall made, and it's a standard form of which TYP, HLP and the professional indemnity insurers must be taken to have been aware. It would no doubt have been open to TYP and HLP, the defendants, to seek to be included as co-insured in the joint names insurance or to have made other arrangements. In reality, the present issue arises between TYP and HLP's indemnity insurers on the one side and the joint names insurers on the other. The latter have provided the full indemnity to give. The real complaint of the former is the failure to take steps to guard against the contingency which has in fact occurred, a contingency which could, in my opinion, have been foreseen had the right questions been asked at the right time. So the apparent inequity is dealt with really by saying you effectively, if you're the defender or defendant, you take the commercial circumstances as you find them. And he does say that it's a standard form of which they must be taken to have been aware, but that doesn't seem to be a central element in whether they're aware of or not. In my submission, he's simply saying that the contract between the plaintiff and the third party can result in a situation where the defendant is unable to convene that third party and obtain a contribution.
It's put most clearly, isn't it, in the last 4 lines of paragraph 2. It absolutely encapsulates your point. That it's a precondition to contribution, there should be a liability, and liability can be excluded by contract.
Yeah. But that is absolutely it. Yes.
The inequity may be marked if the defendant is not party to any of the contractual arrangements at all and inflicts an injury jointly with a third party, in circumstances where he would normally expect the third party to share the consequences. And then it may be a bit tough if the third party says, too bad, I've got an agreement with the claimant, which precludes my liability. It's not unjust, or this injustice will not arise if the duty owed by the third party is one that only arises under a contract, and the very same contract then restricts or removes liability for breach of it, which is probably this case.
Yes.
I suppose also, I mean, most wrongdoing is not committed in reliance upon there being another wrongdoer.
No, exactly so.
Who's also going to cause
Yeah.
the same
Yeah.
damage.
Yeah.
I think.
No, that's right. I mean, that's actually quite important for my submission, that the wrongdoer commits the wrong and is in law liable for, the whole damage. He may be able to find someone else, but he has to take, especially in a commercial context like the North Sea, and one sees in the Charter Party references throughout to this being used in offshore supply, etc. And we'll look at the cases shortly, but the cases make it absolutely clear that one gets this network of hold harmless agreements, etc. So you go into this with your eyes open, and basically as a wrongdoer, you're not entitled to, in my submission, you're not entitled to say, well, there might be others out there that I can hold liable, and I should not be affected by contracts between the injured person and those other people. That would be interfering with my right. The point is that, as well, the Chair mentioned, that the right simply doesn't, the precondition for the right coming into effect isn't satisfied. And I see it as a gloss on taking one's victim as one finds him. One takes the commercial circumstances of the victim and the apportionment of risk in contracts in which that victim is entered into as one finds it. And it's.
I mean, the contractor here could have made whatever contract he wanted with the charterer to protect himself against his very position if he wanted to, and if he could persuade the charterers to agree to it.
Yeah,
Yes.
yeah, that's absolutely right. Of course he could, and indeed, I think we'll see.
And he no doubt entered in insurance arrangements on the contract, on the whatever the true contractual position is, or that would be his alternative step to take.
Yeah.
Well, the contract includes terms as to the insurance that's got to be taken out, doesn't it? Or
It does.
Certainly are such terms. We don't look behind the primary participants to see the realities of this commercial situation.
Yeah, yeah.
Presumably, if they had common insurers, this action wouldn't be existing.
No.
It wouldn't be
Yeah.
possible.
No.
So that
No.
we must assume that although they were affiliates and have a connection, they actually don't have a group insurance.
That's my understanding, my lord. That's right. I mean, if they'd had the joint insurance, the other aspect of this case would have kicked in, as it were, the effect of that. Although, for reasons that I'll come to, I think it is relevant to the clause. But yes, the defender could have made any arrangement it was able to negotiate with the third party, and indeed, when one looks at the cases about the networks of agreements, people simply work on the basis, I think, that the parties have managed to bring themselves into that network of hold harmless clauses. This Enviroco, we say, although it's a matter for the later case, hasn't done that, and that's why we're here.
I suppose it's possible that even if they did have joint insurance, they might not have taken the point that it precluded course of action, because it would help pass some of the liability back to your clients. So.
But I'm not able to assist with whether that was part of their thinking. But Lord Hope deals with the contractual scheme in a bit more detail in the case. I don't think I need to look at the detail, but it's set out quite fully on from pages 96 onwards, culminating really.
Just to try to shorten it, really, the first sentence of paragraph 36 on page 99 shows that it was accepted that if the effect of the main contract was to exclude liability, that was it.
Yeah, that was it. Yeah.
And that seems to be fairly plain, and I think that seems to be common ground all the way through this case.
Yeah, yeah. I mean, there's simply no suggestion in this case, in CRS, that if the contract between the plaintiffs and the third party excluded liability, that the case could be made. It was accepted. The question was then a question of looking at the contractual scheme and seeing whether it did indeed prevent the plaintiff from pursuing the third party, and the answer was it did.
Yes, there was an oddity as to the date at which that matter fell to be tested.
Yes.
Which I then went on to discuss, because the differences between an obligation to make good, I think, and then or an obligation to pay, and I think at the date when the fire damage occurred, it might have been said that they could have been liable, but because of subsequent events that was excluded, and the date when the contribution was sought, it was quite plain that they couldn't be found liable. But I think that needn't trouble us in this case, because we're not concerned with that kind of scenario.
That's right, Mark, but we're not concerned with how the timing affects matters. But that it seems to be clear that it is accepted in this case that if the effect of the main contract was to exclude the third party's liability to compensate the plaintiff, that's an end to the appeal. And my submission, the same point arises here. What I don't look at it in terms of indemnity or exclusion. It's simply a question of looking at the language of clause 33.5 in the Chartered Party. Does that, as the Lord Ordinary and Lord Osborne in the division said, have the effect of preventing the pursuer from recovering from the third party, from the third party being a person who, if sued by me, might have been held liable in an action of damages? And if it has that effect, in the same way as that the exclusion was the end of that appeal, I say that's the end of the
If it's only an indemnity, I mean, as a matter of interest, then the effect in precluding suit in Scotland would, I understand, be because principle, I think, Farstad petis, is that right? The principle that you can't do something if it would be immediately undermined by your having to restore it, or you can't get something. Is that a procedural principle or a substantive principle? I.e., does it offer a substantive defence?
Yeah.
I mean, if it were a procedural principle, then it might be said that if suit had been brought in the right jurisdiction, or another one, where it didn't apply, then that was no answer. On the other hand, one might look at English law, which is the substantive governing law under the Charter, and security action is commonly regarded as a defence, by which I would normally understand a substantive defence, but I think one might want to be educated on that.
But my position on it is that it is a substantive defence, and indeed one sees in this case just on that point. It's really in a later chapter of the submission, but just on the very point the Lord raises, Lord Bingham, in paragraph 7 on page 94, says that under the contract and Wimpey's all risks insurance policy, CRS would be effectively indemnified by the insurer's provision of a fund enabling it to pay Wimpey for repairing the fire damage. The insurers could not then make a subrogated claim against Wimpey because Wimpey was a party co-insured with CRS under the policy, and the insurers would be obliged to indemnify Wimpey against any liability which might be established, an obvious absurdity. And he then talks about the rationale being a matter of controversy, but Lord Hope deals with it further on page 104, just on whether security is the right concept. Paragraph 65 on page 104, Your Lordship says that although Your Lordships do not need to resolve the issue in this case, it seems to me there is much force in the point that rules about security of action do not provide the explanation. I would prefer to say the true basis of the rule is to be found in the contract between the parties. In the Hopewell case, Mr. Recorder Jackson QC said that in his view it would be nonsensical if those parties who were jointly insured under a contractor's all-risk policy could make claims against one another in respect of damage to the contract works, that such a result could not possibly have been intended by those parties, and that had it been necessary for him to do so, he would have held that it was an implied term to that effect. Now, applying that kind of language to the present case, looking at the contract between the pursuers and the third party, and using Lord Hope's analysis of it, one would have to ask, was it the intention of the parties to the Charter Party that this pursuer could hold the third party liable in damages or expenses, standing clause 33.5. And so I suppose what comes round to the point my Lord made about the Scottish approach to it, I would simply adopt that approach and say, looking at it as a matter of the intention of the parties to the Charter Party,
You'd say if
that's enough.
clear intention to exclude liability,
Yeah.
effectively.
Yeah, that's what it
If
comes
you
to.
exclude third parties and just consider a contract between two individuals, individual A contracts to provide services for individual B, and individual B says, I will hold you indemnified against any claim I may have against you.
Yeah.
The only way you make sense of that is to say, I won't make any claim against
Exactly. Well, exactly so, my lord. And that is a crucial observation, if I may respectfully say so, because what it means is that, and this is what the Lord Ordinary says, and I think Lord Osborne in the division takes the same point. This characterisation argument, it's an indemnity rather than an exclusion clause, and therefore, you know, the appellant's points are somehow undermined by that. Both the Lord Ordinary and to some extent at least Lord Osborne say, well, it doesn't make any difference if you simply call it an indemnity. You know, just looking at the matter, practically speaking, it's nonsensical, it seems to me, that even just in the indemnity context, that one can figure an action of damages by me against the third party in which the third party is held liable when I have, if it is simply an indemnity. And it's quite how one pigeonholes it may not matter, but I pigeonhole it simply as saying, looking at the intention of the contracting parties, you know, sensibly and realistically, was it ever intended that I would sue ASCO in damages and they would be held liable, and then I would indemnify after that?
Or maybe the Latin maxim sums it up rather nicely.
Yeah.
Yes. Yes. Yes.
I was very puzzled by one passage in Lady Peyton's judgment, which, page 59, which seemed to postulate that parties couldn't have intended to relieve the charterers from liability. About a third of the way down,
Yeah.
paragraph 40, sorry, paragraph 39, she says, I don't accept that should be read into the clause after the word liabilities, words such as arising from a claim by any party other than Farstad, yet on the basis of Farstad's argument, such words would require to be implied, for if they were not, liabilities would prima facie include a liability of Farstad arising from negligence on the part of ASCO, causing loss or damage in relation to the vessel. That seems to postulate that the last thing you would have agreed was to exclude the charterers from liability. But you weren't arguing that, presumably.
No.
I mean, I think you accept that's the first thing you intended to do.
Indeed.
Yes.
That's the point of the argument, that you know, that's what these knock for knock, hold harmless agreements amount to, that they won't bother each other. And what I would say on it is that when one digs into the cases about these hold harmless clauses in the North Sea, one actually finds a series of cases where the judges say, well, that's what it's really all about. You're agreeing effectively not to bring proceedings at all. Lords, I see that is...
Yes, it's time to adjourn.
1 o'clock.